Election Board to order. We'll start with the Pledge of Allegiance. Please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We have the agenda. Are there any additions or corrections to the agenda? No. The first item is to approve the order of the Brown County Election Board approving the proposed vote center plan. This plan has been, or the facts regarding this plan have been studied extensively with respect to, or by the study committee that was established back last winter. It has been approved by that committee, and recently the Board of Commissioners approved the satellite office for absentee voting in the 2026 election, the clerk's satellite office, which was necessary. So with that, we have everything that we need to approve this proposed vote center plan. Is there a motion to approve the plan?
So moved.
Second.
Mr. Kelly moves to approve the plan, and Ms. Banks seconds the motion. Mr. Kelly, how do you vote?
Aye.
Ms. Banks, how do you vote?
Aye.
Chair votes aye. Plan is approved. The second item on the agenda is to set a date, time, and place of the public meeting for the board to display and explain the plan, the vote center plan. At that meeting, individuals may make written comments, or they may mail or email in their written comments. There will be press releases, and on the website, all of this is explained in detail as to how to send in that information. We'll consider, the board will then consider all of those comments and hold a final public meeting after taking those comments into account on September 29th.
Correct.
On September 29th, and at that time, the plan is for the plan to be finalized and approved by the board, and once that is done, then it will go to the council for their approval and to the commissioners for their approval, then to the state election board. That's the plan. So the chair proposes that the public meeting to hear and consider the order of the Brown County Election Board approving the proposed vote center plan be held on August 28th, 2025 at 6 p.m. in the Sandman Room here in the Courthouse Extension County Office Building. Is there a motion to the, for this meeting?
So moved.
Mr. Kelly moves.
A second.
Ms. Banks seconds the motion. Mr. Kelly, how do you vote?
Aye.
Ms. Banks, how do you vote?
Aye.
Chair votes aye. Matter is confirmed, and the public meeting to disclose and explain and take comments on the proposed vote center plan will be held on August 28, 2025 at 6 p.m. in the Salmon Room. We're going to be busy signing some documents here, and then we're going to come back. Sign that for me.
Sherry, your press release is good to go.
Sorry, what?
Your press release is good to go.
Thank you. So you don't need my paper copies, because I know I sent it at the last minute.
Nope, I printed them and brought them with.
Thank you.
I want to take the opportunity to thank all of the members of the Vote Center Study Committee, Mark Bowman, Laura Lewis, two members of the board, Darren Burton. Darren Bird, he's always sitting right there, and Amy, Oliver, Sherry Frank. This was a bipartisan effort. A lot of work done. It's a good product. I want to also thank Emily Callahan, the Superintendent of Education, and the school board for all of their valuable assistance. I want to thank the Board of Commissioners for working hard to find us a place for a satellite office. And I want to also thank the Fair Board for working with us to find a good location with plenty of up-close level parking for that satellite location. Can I have that last thing I gave you, son? Okay. So we're not done with that, but as Churchill once said, it's not the end, it's not even the beginning of the end, but it's certainly the end of the beginning, and that's kind of where we are. Okay, the last thing I want to discuss is I need to make a disclosure under the Open Records Law of an action taken by the Election Board in executive session on July 28, 2025. And to put, this is a little complicated, but to put it all in perspective, for the reason for that meeting, we need to start at the beginning. On July the 2nd, 2025, as I received an email in my capacity as president of the Brown County Election Board from Richard Stanley, And the subject was a potential lawsuit against the Brown County Election Board. And it says, and I quote, attached here to for your review is a draft complaint against the Brown County Election Board. I am also forwarding to you plaintiff's exhibits 1 through 9 to be filed with the complaint. I intend to file this complaint on behalf of myself and Tim Clark in the Southern District of Indiana if the election board does not issue a written statement by July 24th, 2025, clearly stating that the election board will not enforce the decision of the Indiana Republican Party against myself and Mr. Clark by preventing myself and Mr. Clark from running for elected office as Republicans. Please feel free to contact me if you have any questions or comments. Then that afternoon, I emailed back to Mr. Stanley. Dear Mr. Stanley, thank you for your courtesy letter notifying the election board of your planned lawsuit. The election board has been no party to the matters you cite. You asked the board to take action based on a hypothetical situation. I do not speak for all members of the election board, but as chair, I will not bring your request up in advance of July 24 for the following reasons. One, the clerk will not attend the meeting scheduled for July 8th, as she will be attending a meeting of county clerks, and Rick Kelly will not attend as he will be out of town. Therefore, the meeting on the 8th will be canceled. No other election board meeting is scheduled before July 24th. Regarding primary candidate challenges, the election board is in the business of applying the law based in part on facts taken from witnesses having been placed under oath and before the board in a public meeting. The law will control in any event. The election board does not make law. That is the role of the General Assembly and the courts. I see no good reason why the board should issue an advance advisory opinion. That action would be bad precedent and of dubious value as a matter of law. Of course, it is for Mr. Clark and you to take whatever action you may deem appropriate, given the concerns that you allege. I do not presume to persuade you as to any action or the timing thereof you may choose. Very truly yours, Mark I. Williams, Chair, Brown County Election Board. And then I received a response back on the same day from Mr. Stanley. Dear Mark, I take your response to be evasive, and I believe the court will see it that way as well. I have no doubt that the election board has the ability to meet in an executive session at any time it wishes to evaluate the merits of this possible lawsuit, and you have not denied that. I would prefer to have a clear answer from the election board as to how they intend to respond to this matter. But if you refuse to provide any clarity on this matter, it will be fair for myself and the court to interpret your refusal as an intention to enforce the Indiana Republican Party's decision against us. As to your point that we are requesting an improper advisory opinion and should wait until candidate objections can be made after we officially begin our candidacies, you are legally wrong on that point. This is a justiciable controversy at this point in time, and I am confident that the court will entertain our lawsuit despite your specious argument. It seems that you have made a decision on behalf of the election board to fight this matter. Does that mean that the election board is refusing to issue the written statement that I requested so that I can go ahead and file the lawsuit immediately without waiting until July 24th? Any additional evasiveness on your part will be brought to the attention of the court. Signed, Rich. And then I did not answer that. And then later, I received just an email that says, that was on the 16th of July, I received this email. Dear Mark, I am following up on my previous correspondence regarding the possible lawsuit I notified you of. As I indicated below, it would be helpful if you would provide some clarity on how the election board intends to treat the decision of the Indiana Republican Party against myself and Tim Clark. You should understand that a refusal by you to provide any clarity whatsoever on this matter should be reasonably interpreted by myself, Tim, and the court to reflect an intention by the election board to enforce the Indiana Republican Party's decision against myself and Tim. I'm confident that the court will agree with me that the unwillingness of the election board to clearly state that it will not enforce the Indiana Republican Party's decision against myself and Tim creates a justiciable controversy that can be remedied by the court. Therefore, unless the election board issues a written statement by July 24th, 2025, clearly stating that the Indiana Republican Party's decision will not be enforced against myself and Tim, I will proceed to file a lawsuit against the Brown County Election Board in the District Court for the Southern District of Indiana. And that's federal court. So, so nothing more was heard by the members of the election board. So on July 28th, 2025, the election board met in executive session, and here are the minutes of that meeting. Minutes of the Brown County, Indiana election board meeting in executive session July 28, 2025 at 9:30 a.m. in room C of the Brown County Public Library. The Brown County Election Board, meaning the board, met in executive session for the purpose of discussing threatened federal district court action filed against the board by two residents of Brown County regarding each of their potential candidacies for election to county offices in upcoming elections. Present were Mark Williams, chair, Rick Kelly, member, and Perlita Banks, clerk and secretary of the board. In the opinion of the board, the demand made to the board in connection with the relief sought in the threatened lawsuit is not within the lawful power of the board to provide. And therefore, if the threatened lawsuit is filed, the board, according to its legal responsibilities, will defend itself. Upon motion by Mr. Kelly and second by Ms. Banks, it was unanimously agreed that Mark Williams, in his capacity as chairman, be authorized to retain counsel to defend the board against any such lawsuit, provided such actions by Mr. Williams is taken subsequent to the filing of any such lawsuit against the board, regardless of whatsoever court and jurisdiction such lawsuit may be filed. That being all the business to come before the board, the meeting was adjourned. Signed, Mark Williams, Rick Kelly, and Perlita Banks. Now, the resolution or the minutes and the motion was vague because at the time we held this meeting, we didn't have any idea whether or not a case would ever be filed, and we most certainly had to disclose that the contents of this meeting and the reasons for it according to the open door law. But at the same time, if there was not a case filed, we didn't want to unnecessarily draw any attention to the individuals who were threatening the lawsuit. So those minutes will be attached to the minutes of this meeting. And the statute that the election board referred to was Indiana Code 36514, powers and duties of the election board. Each county election board, in addition to the duties otherwise prescribed by law, shall do the following: conduct all elections and administer the election laws within the county, except as provided in Indiana Code 3-8-5 and Indiana Code 3-10-7 for town conventions and municipal elections in certain small towns. Prepare all ballots and distribute all ballots to all of the precincts in the county, not later than the Monday before distributing ballots and voting systems to the precincts in the county. The county election board shall notify the county chairman of each major political party, and upon request, the chairman of any other bona fide political party in the county, that sample ballots are available for inspection. That's the duties of the election board. So, after the executive session was held, on the way from the library back to the courthouse, the clerk stopped at the post office to get the mail and found the summons that was threatened, and it is a summons in a civil action. United States District Court for the Southern District of Indiana, sitting in Indianapolis, I believe. Richard Stanley Jr. and Tim Clark, plaintiffs, versus Brown County Election Board, civil action number 25-1482-TWP-MKK, and TWP is the initials of the federal district judge assigned to the case, and MKK are the initials of the United States magistrate. The complaint reads as follows. On December 20, 2024, plaintiff Mr. Clark filed a complaint with the Indiana Republican Party, claiming that the chairman of the local Republican Party violated, and I'm reading verbatim from the complaint that was attached to the summons, violated GOP Rule 1-25, and he attached exhibits 1 through 4 relative to that. In Mr. Clark's complaint, Mr. Clark requested that the Indiana Republican Party remove the local Republican chairman from his office and ban him from running for elected office for 5 years as a Republican. Mr. Clark was represented by Mr. Stanley, by plaintiff Mr. Stanley, in his complaint before the Indiana Republican Party. On January 23, 2025, the District 9 officers of the Indiana Republican Party held a hearing on Mr. Clark's complaint. At the end of the hearing, the District 9 officers issued a written decision dismissing Mr. Clark's complaint against the local Republican chairman, Plaintiff's Exhibit 5. Additionally, the District 9 officers' decision determined that Mr. Stanley and Mr. Clark are not Republicans in good standing for a period of 5 years. 3. On February 5, 2025, Mr. Stanley and Mr. Clark filed an appeal with the state GOP, arguing that the District 9 officers' decision should be overturned, Plaintiff's Exhibit 6. On May 14, 2025, the state GOP issued an unappealable written decision upholding the District 9 officers' decision in its entirety, Plaintiff's Exhibit 7. In view of the legal precedent of Hero versus Lake County Election Board, 42 Fed 4th 768, 2022, Mr. Stanley and Mr. Clark are now subject to being prevented from running for election as Republicans by the Brown County Election Board. 6, Mr. Stanley has become concerned about dysfunction in his local government and corruption in the local Republican Party. For these and other reasons, Mr. Stanley intends to run for elected office in Brown County as a Republican, Plaintiff's Exhibit 8. 7, Mr. Clark ran for election in 2024 as a Republican for County Commissioner and won both the Republican primary and the general election and currently holds that office. Mr. Clark intends to run again for the same elected position he currently holds as a Republican in the 2028 election, Plaintiff's Exhibit 9. Number 8, on July 2nd, 2025, Mr. Stanley sent a copy of a draft complaint to the Brown County Election Board and requested that the Brown County Election Board issue a written statement refusing to enforce the decision of the Indiana Republican Party against Mr. Stanley and Mr. Clark, Plaintiff's Exhibit 10. On that same day, the chairman of the Brown County Election Board responded to Mr. Stanley's notice, but refused to state whether or not the Brown County Election Board intends to enforce the Indiana Republican Party's decision against Mr. Stanley and Mr. Clark, Plaintiff's Exhibit 10. On July 16, 2025, Mr. Stanley sent a follow-up reminder to the Brown County Election Board about the potential lawsuit, Plaintiff's Exhibit 10. However, the Brown County Election Board has refused to provide any further response to Mr. Stanley. Number 9, Mr. Stanley and Mr. Clark assert that the decision of the Indiana Republican Party against Mr. Stanley is based on false evidence and they knew it. 10, Mr. Stanley and Mr. Clark assert that the decision of the Indiana Republican Party against Mr. Clark is too vague for judicial review. Number 11, Mr. Stanley and Mr. Clark assert that the decision of the Indiana Republican Party against Mr. Stanley and Mr. Clark would violate the U.S. constitutional protection of due process if enforced by the Brown County Election Board. Number 12, Mr. Stanley and Mr. Clark assert that the decision of the Indiana Republican Party against Mr. Stanley and Mr. Clark would violate the U.S. constitutional protection of equal protection if enforced by the Brown County Election Board. 13, Mr. Stanley and Mr. Clark assert that the decision of the Indiana Republican Party against Mr. Stanley and Mr. Clark would violate the U.S. constitutional protection of freedom of speech if enforced by the Brown County Election Board. 14, Mr. Stanley and Mr. Clark assert that the court has jurisdiction of this case pursuant to 28 United States Code Section 1331. Mr. Stanley and Mr. Clark assert that venue is proper in this district pursuant to 28 United States Code Section 1391. Number 16, Mr. Stanley and Mr. Clark assert that declaratory relief is authorized by Rule 57 of the Federal Rules of Civil Procedure and 28 United States Code Sections 2201 and 2202. Number 17, Mr. Stanley and Mr. Clark have brought this action pursuant to 42 United States Code Section 1983 to redress the deprivation under color of state law of rights secured by the Constitution of the United States. 18, Mr. Stanley and Mr. Clark request that the court issue a permanent injunction enjoining the Brown County Election Board from enforcing the Indiana Republican Party's decision against Mr. Stanley and Mr. Clark. 19, Mr. Stanley and Mr. Clark request that the court award Mr. Stanley and Mr. Clark their costs and attorney's fees pursuant to 42 United States Code Section 1988, signed July 25th, 2025 by Richard E. Stanley Jr., Indiana Attorney Number 31838-49. Now, one more document, if you can bear with me. The case, the complaint mentions Hero versus the Lake County Election Board in paragraph 5. In view of the legal precedent of Hero versus the Lake County Election Board, 42 Fed 4th 768 2022, Mr. Stanley and Mr. Clark are now subject to being prevented from running for election as Republicans by the Brown County Election Board. Okay, so this case is filed in federal district court. The federal district court is in the 7th United States Circuit Court of Appeals jurisdiction. And the 2nd United States Circuit Court, 7th United States Circuit Court of Appeals sits in Chicago. You have, in the federal system, you have the federal district court, that's the trial court. You have the Court of Appeals, that's the First Appellate Division, and then you have the Supreme Court of the United States. So this case, the Hero case, was filed in the federal court in the Northern District of Indiana. Indiana has 2 federal districts. This is filed up north. And the case was decided, to which Mr. Stanley refers, by the United States Court of Appeals for the 7th Circuit. And that citation, 42 Federal Reporter 4th 768, is sort of the library number. If you were looking for that case in a great big legal library, if you punch that in, that's where you'll find that case. So this case was Joseph Hero, plaintiff in the Court of Appeals, versus Lake County Election Board, the defendant or appellee in the Court of Appeals. And it was decided August 2nd, 22. Just a little background, and this is the opinion of the court. Political candidate filed Section 1983 action seeking declaratory judgment that the county election boards striking his name from the primary ballot in past election at state political parties' behest violated his rights under the First and 14th Amendments, an injunction prohibiting it from similar conduct in future elections. The United States District Court for the Northern District of Indiana dismissed the complaint and candidate appealed. So it goes up to the Court of Appeals, and in this case, you're welcome to find it and read it. There's a great deal of discussion about the jurisdiction of the federal courts as it regards the circumstance of this case. It's relatively complex, but the Court of Appeals actually dealt with this case on the merits and dealt with it substantively, not just procedurally. So here comes that part of the opinion. This is written by St. Eve, Circuit Judge. Joseph Hero has been a registered Republican for 40 years. He supported Republican candidates, voted in Republican primaries for decades, and even ran for office as a Republican with occasional success. But local politics can be messy. Heroes Town Council decided to exercise its eminent domain authority to seize property of low-income residents. Hero opposed the measure and backed independent candidates to replace 2 incumbent Republican council members. Upon learning of his actions, the Indiana Republican Party banned him from the Republican Party for 10 years. Undeterred, Hero tried to appear as a Republican candidate in the 2019 election. He met all the criteria established by Indiana law, but the party objected to his status, and the Lake County Election Board sided with the party, striking his name from the ballot. Hero sued the election board seeking declaratory relief that his rights were violated in the past election and an injunction prohibiting the election board from similar conduct in future elections. The district court dismissed for lack of jurisdiction. We affirm. So that means the Court of Appeals agrees with the district court that it should have been dismissed for lack of jurisdiction. Excuse me, I apologize. That's not the case. The Court of Appeals says we affirm, albeit on a different basis. So they didn't, the district court dismissed for lack of jurisdiction. The Court of Appeals affirmed the decision of the district court, but decided it on a different basis. Excuse me for that confusion. So I go on. In 2015, St. John got swept up, that's a town, in Mr. Hero's, in which he is a resident. St. John got swept up in a polarizing debate over eminent domain. The St. John Town Council, comprised exclusively of 5 Republican members, voted to seize private residences for a commercial development. Some residents were unhappy because this decision would have primarily affected lower income homeowners who had been living in the area all their lives. They formed a local political action committee to elect 2 independent candidates for town council, running against the incumbent candidate. Hero lent his support to the effort, offering one of the independent candidates was also a Republican. In this election, was the only instance in which he openly campaigned for the defeat of a Republican candidate. The state Republican Party, however, caught wind of Hero's efforts to oust Republican incumbents. The year after the contentious events, Hero ran to retain his position as St. John Precinct Committeeman and delegate to the Republican State Convention. The Republican Party officials determined that because he supported the independent candidates in the town council election, he could not serve in these capacities. Shortly after, Hero received a letter from the state chairman of the Republican Party informing him that for the next 10 years he was not a Republican in good standing, and thus barring him from seeking elected office in Indiana as a Republican during that time. Undeterred by the letter, in 2019, Hero declared his candidacy for an at-large seat on the St. John Town Council. Under Indiana law, there are only 3 ways to appear on an election ballot. First, a candidate of a major political party can file a declaration of candidacy for a party if either he voted in the last primary election or the county chairman certifies that the candidate is a member of the political party. Second, a candidate can run as an independent by obtaining 2% of the total vote cast in the last election. And third, a candidate can appear as a write-in option. Despite meeting the requirements to appear on the Republican primary ballot in 2019, the chairman of the Lake County Republican Party and a member of the Lake County Council challenged Hero's candidacy. The Lake County Election Board held a hearing on February 26, 2019. Hero explained that he met the requirements under Indiana law to be a Republican in the upcoming primary election. He presented an opinion from an attorney for the Indiana Election Division and a printout of every Republican primary he had voted in since the mid-1980s. The challengers conceded that Hero met the qualifications for affiliation under Indiana Code 3-8-27A4, but he maintained that Hero could not run based on, quote, an actual order from the party chairman in Indiana, end quote. The the election board unanimously ruled against Hero and removed his name from the Republican primary ballot. And I go on and get to the part of the decision that's based upon election law. We turn now to the merits. The First and 14th Amendments safeguard the rights of citizens and political parties to participate in the electoral system. We have stated that the Anderson-Burdick test applies to all First and 14th Amendment challenges to state election laws. The resulting test requires courts to engage in a two-part inquiry. First, we must determine whether the law imposes severe or reasonable and non-discriminatory restrictions on candidates and voters' constitutional rights so that we can ensure application of the appropriate level of scrutiny. Second, we must determine whether the state interest offered in support of the law is sufficiently weighty under the appropriate level of scrutiny. The election board did not violate Hero's First and 14th Amendment rights. The decision to strike Hero's name from the ballot imposed only a minor restriction on his ballot access. Indiana law provides alternative means to access the general election ballot. Although Hero cannot run in the Republican primary, undoubtedly his first choice, he can either run as an independent by obtaining 2% of the total vote cast in the last election, or as a write-in candidate. As an independent, he can tout his Republican virtues, tell voters he supports Republicans, put up yard signs to that effect, and run on a platform identical to any political party. The only limitation is that he cannot appear on the Republican Party's primary ballot. The restriction here is also reasonable and non-discriminatory. The state has an interest in protecting a party's right to determine its own membership and limit its candidates to those party members. Implicit in the First Amendment is the freedom, quote, to associate with others in pursuit of a wide variety of political, social, economic, educational, religious, and cultural ends, end quote. Quote, the forced inclusion of an unwanted person in a group infringes the group's freedom of expressive association if the presence of that person affects in a significant way the group's ability to advocate public or private viewpoints, end quote. Political parties enjoy these associational rights like any other organization, and, quote, in no area is the political association's right to exclude more important than in the process of selecting its nominee, end quote. So that and a lot of other comment, most of it dealing with technical jurisdiction issues, was the decision of the Seventh Circuit, which, at least in my service, indicated it was still good law. So that's as a result of all this, the election board has hired an attorney to represent its interest against the claims of Mr. Stanley and Brown County Election Board. And the election board has an appointment, and it will be on the agenda of the county council at its August 18th meeting to explain this matter to the council and to discuss the fiscal impact to the county of this lawsuit. So it took a little while, but I wanted everyone to be fully informed, and the matters that I have read come from the emails of Mr. Stanley, my responses to those emails, the minutes of the Brown County Election Board meeting held on the 28th, where we decided to hire a lawyer, the summons by Richard Stanley and Tim Clark against the Brown County Election Board, and I read directly from the opinion of the 7th United States Circuit Court of Appeals and the Hero versus Lake case, which was cited by Mr. Stanley in his complaint. So that's where this matter is. I won't discuss any of it, but those are all the facts. Is there anything else to come before the election board today?
I would like to bring up the next scheduled election board meeting on September the 9th. I will be at a clerk's conference on the 9th. So will you gentlemen convene and conduct that meeting, or are we going to forego it?
Let's see, September the 9th. Is there any business that we know of that will come before the board at that meeting?
None that I'm aware of.
No, nothing I'm aware of. The next meeting, so the meeting on the 9th of the election board is canceled, and the next meeting, that'll give the county council more time for their sessions. The next meeting of the election board after that will be Monday, the
First.
no, it'll be the 29th of September.
Oh yes, the 29th is when we will hear.
So the 29th will be the meeting where the board will hold a public meeting and go. I will read all of the written comments that the board receives regarding the election or the vote center plan. I will. You have your hand up.
Yeah. We have a meeting on the 30th at 1. Is that what you mean? The 29th is the deadline for public comment?
You're right. I apologize. The 29th is the deadline for public comment, and the meeting will be held on Tuesday, September 30th at 1 p.m.
Correct.
Thank you, Sherry. Then there will be, and I'll read all those comments, and I'll give individuals who are here an opportunity to comment, and then Wednesday, October the 1st at 9 a.m.
Correct.
there will be a final hearing on the vote center plan for action by the board. And if the vote center plan passes by unanimous vote, then it will go to the commissioners and to the council. Okay? Anything else?
Nothing.
Is there a motion to adjourn?
So moved.
Meeting is adjourned.